The embattled National Assembly Speaker, Nosiviwe Mapisa-Nqakula, will know her fate tomorrow on her bid to challenge her impending arrest over a multi-million rand bribery claims. Now, during the Speaker's urgent interdict against her, the lawyers representing her accused the NPA of what they say are delinquent tactics that infringe on their clients' rights. Mapisa-Nqakula is accused of receiving over 2 million rand in bribes for tenders while she was still the Minister of Defence. To help us unpack the possible implications of tomorrow's ruling, I'm joined by Abigail Ngobene, and she is a legal expert. Ms. Ngobene, good evening to you, and thank you for your time. So let's recap a bit here. The Speaker, through her lawyers, she wants the court to order law enforcement to basically summon her to court instead of arresting her. Have you ever heard of something like this before, and what are her chances of success?
Well, Oli, thank you very much for having me, and I greet the viewers of Newzroom Afrika at home. It is one of its own kind, and I don't see why the Speaker should, in a way, try to bar or to deter the NPA as well as the SAPS from discharging what is their main duties and fulfilling their mandates in terms of their empowering legislations. And to take this further, I would say, Oli, that the fact that she says she will suffer a reputational harm and a reputational damage, it is so with everyone who is brought before the criminal court for charges. Every South African citizen have some level of reputation to protect. And if they are faced with such kind of instances where they have to be brought before the court of law, unfortunately, the criminal justice system of South Africa has a process on how it needs to unfold. And with the rule to equality, everyone should be treated and subjected to such a process.
As you say, that perhaps one of the biggest conundrums for the Speaker is that word you used, her reputation, and therefore, yes, if such a process is going to unfold, South Africa, if and when she is ultimately arrested, I'm sure for a long time, as we did see with the former President Jacob Zuma appearing in the dock, that is one of the images that will probably, yes, be forever etched in our minds. How important is, yes, it then for the National Prosecuting Authority to have their ducks in a row so that they are not later sued for defaming her?
I think that is a very important aspect that you are raising, Oli, that in the previous occasions we have seen the SAPS and the NPA fulfilling their duties without having thoroughly investigated their matters. They will bring a charge today and tomorrow the charge is withdrawn. And that then the people that are brought before the court suffer such damages and they cannot reverse that. So one would be to conscientize the NPA and the SAPS to say, when conducting investigations, it's very important to be alive to the elements of an offense. The evidence should fit within the allegations that the person is being brought for. And at all material times, they should not just arrest. They must arrest when they have confidence that when the matter goes to trial court, they are able to convict or prosecute successfully. It does not help to arrest a person, bring them before a criminal court when you have not tightened your case. So I would say that with the previous cases where high-profile people were arrested and later withdrawn, it raises a question on whether the capacity issues on the side of NPA and SAPS to investigate matters, is it something that South Africans should be worried about?
Still on this point of reputational damage.
Yes.
what areas of interest or what areas of argument do you think that the court will need to apply its mind to, given the issues that she has raised? Because already, a day after the court proceedings, I would listen on radio as any South African would have, and there were strong suggestions of preferential treatment to say, if it were anybody else, if it were me, that law enforcement needed to arrest, all of this court process would not have been entertained, because they would have said, you are under arrest, you will appear in court in all probability the following day if it is too late in the day, and therefore the process unfold as we know it. That's how we have always known the South African law enforcement authorities to function. Did she receive special treatment, perhaps?
It's very dynamic to be straightforward to your question. But these are the aspects that I want to bring home. To say, in South Africa, there is a rule which says everyone is equal before the law. That's number one. Number two, there is a rule that there is a presumption of innocence until a person is proven guilty by the court of law. And as it stands, there is no suggestion that the Speaker of the National Assembly is guilty at this stage of an offense. They are only saying there is a reasonable suspicion that there was a commission of an offense. And what happens after that? She must be processed like any other South African in the criminal court, and I'm told that the offenses that she's likely to be charged with are Schedule 5 offense, where she will have to also come to court and present personal circumstances. Unfortunately enough, when we listened to the argument, they said the state was not intending to oppose bail, and part of the content that came out of the argument was that they wanted to conduct this kind of processing in a manner that is seamless, to say, to avoid grandstanding, to avoid such kind of humiliation. And I think the Speaker, in bringing this application from where I'm sitting, it was not necessarily a necessity, because the way in which the NPA was intending to approach this was not necessarily to humiliate her to that extent. But I'm also alive, only when we talk reputational harm, of the points that she raised on the step-aside rule, which is a rule within the ambit of the ANC, which does not necessarily feature in the criminal justice system. And I say, when we consider a reputational, or rather a preferential treatment, I would say I don't want to say she did receive a preferential treatment, but I would believe that as it will happen to any South African, she was supposed to have been brought to court following such channels. Because if you look at this particular case, if the court grants this application, we are likely to have influx of litigations, which will be then saying those who have money will bring matters to court to interdict the SAPS and NPA from executing their lawfully statutory functions.
You mentioned the schedule that she is facing. Yes. I'd like for you to just elucidate that a little bit more for us, because, and I'm going to remind us all here, because this was ventilated in court, she is said to be charged with 12 counts of corruption for allegedly receiving gratifications amounting to just over 4.5 million rand. So if it's a Schedule 5 offense, who has the responsibility to prove to a court that they can be admitted to bail?
Well, you know, with Schedule 5 and Schedule 6 offenses, a bail application has to happen. And I know that the Speaker would have to come to court, place the personal circumstances to the court, and also state to the court that she does not have a pending case nor a previous conviction. And in her view, the interest of justice does allow her release on bail. And she's fortunate enough that from the arguments we had, that the state was was not intending to oppose bail, which will just be a formality to say she deposed to an affidavit, putting the court into confidence that she will stand trial, placing her personal circumstances there too, and of course she will be granted bail. And of course sometimes the court will then grant conditions on how the accused person will have to behave going forward. But of course the defense as well only raised, the applicant's counsel raised a lot of issues as to the rights of the accused person in terms of Section 35 of the Constitution. And you will note that those rights are available to a person who is either arrested, detained, or accused. And at this stage, there is no indication that her rights will be violated.
As a final question to you, and I know now this is very presumptuous, I'm really testing your legal finesse here. The person that is understood to be the state's witness, that is who the state relies on. The understanding is that they are a Section 204 witness, which means that they have implicated themselves. However, they have immunity from prosecution because they have committed to telling the truth, the full truth. How likely is it that this case would fall apart and be a further embarrassment to the NPA?
Remember, Toli, that the point of departure would be that the NPA should have enough evidence upon which they say, I have confidence that if I go to the trial court, all witnesses and evidence that will be brought before the court will be admissible evidence and will, in the interest of justice, be admitted as such. And I have confidence that all the witnesses that I'm going to call are going to support the state's case. And if they have entered into a negotiation with a Section 204 witness, I think they have access to say they will be able to utilize that piece of evidence to their benefit. Of course, you'd remember, Tony, that in a trial court, such a witness will be cross-examined, such a witness will then, his evidence will be put to test, and it will be for the court to come up with a verdict at a later stage.
Abigail Ngobene, thank you very much for your time. A legal expert trying to put this in plain language for you and me. Thank you very much for the explanation.